Tip top of the morning to you. It is Tuesday morning. Yesterday my boss and I have been going around and around. He is adamant that a arbitration or mediation clause in a contract for legal services in California can't be inserted into a contract unless the potential client is given the opportunity for third-party review, or maybe without the client having a third-party review of that arbitration clause. Now, I, on the other hand, have been solidly of the position that the state bar says it's okay. I can't find any cases that say it's not okay. I'm pretty solidly of the opinion that it is entirely okay to put in. The state bar literally has samples, practice guides on the language to use and how to use it in your contract for legal services. And I know that the lawyer haters out there are gonna be like, it's a trick, it's a ploy. No, actually, it came about. California's Civil Arbitration Act came about because it's cheaper to go through arbitration than it is to go to trial. And there's a lot of disparity between people and their incomes, and you can bury someone in paper if you have enough money and enough lawyers. And that's no good. And so that's why California passed the Civil Arbitration Act. And then California then passed the Mandatory Fee Arbitration Act, which affects lawyers. And what that is if there's a fee dispute, it doesn't go as far as the California Civil Arbitration Act, but if there's a fee dispute between a lawyer and a client, the client gets the choice of whether or not they want to take it into arbitration. And the lawyer can ask the client to take it into arbitration, but that's about it. I have found where they've contracted it in, and it's acceptable if the lawyer puts it into his contract as a binding, or as a clause for binding arbitration or required MFAA arbitration. But again, that is directly a result of the disparity in a lawyer's ability to drown a layperson in paperwork. And, if you can't dazzle them with your brilliance, you can baffle them with your bullshit. And that's not good. So it is a response that California has come up to reduce the disparity between lawyers and clients when it comes to fee disputes. But again, I think you can see that there's a huge legislative favor towards arbitration, and so there is nothing that says you can't put these in your legal services contract. Well, as luck would have it, the whole reason why I'm looking into this is we have a client who's wanting to sue a couple lawyers for malpractice, and one of those lawyers put in a mandatory arbitration clause, and the other one put in a mandatory binding arbitration clause. So I was told in no uncertain terms that I was going to go out and I was going to find the case that makes it improper for the arbitration clause. turns out I had done a heck of a lot of work trying to find a way to get out of the mediation clause as well, but it turns out that strategy-wise, my boss decided it would be better, strategy-wise, save the client money, all this other fun stuff, gives us 2 cracks at the bat to go ahead and go through mediation, so I dropped that. So as far as the arbitration is concerned, I ended up finding a case. I'm so happy. It's the 1986 California Court of Appeals case, and it's not entirely on point. It certainly won't survive any like if a judge looks at it, a judge is gonna be like, "Come on, dude." But apparently, this particular lawyer isn't one who wants to go to court. He's not a trial attorney. He's more of a paperwork attorney. So if he wants to challenge us on it, he's gonna have to put on his big boy go into court shoes, and we don't think he's gonna want to do that. And there's nothing settled in law. Even if it's settled, it's surprisingly not settled. So who knows? All the underlying things that I put in there are still true, and it's still a good case. It hasn't been overruled or anything like that, but there are cases that are more on point. I found a case that was saying basically that because the arbitration clause in the contract in that case was run right up after 5 paragraphs of discussions of fee, and the mandatory arbitration clause itself was saying if there's a dispute with attorney fees or costs or any other matter, then it's binding arbitration. The court said, well, it looks like you were just talking about fees. The client thought you were just talking about fees and costs and things like that. They didn't think you were talking about malpractice, and they need to know what they're actually signing away before they sign it away. And so, ergo, your arbitration clause was invalid. So it certainly won't stand up to this particular lawyer's. His arbitration clause had none of the defects that the arbitration clause in this case did. Got to remember, there's 40 years of refinement between that case and his contract, and his contract is pretty much modeled basically right on the practice guide model from the state bar. So, but anyway, I'm super stoked that I found a case that kind of sort of ish, and so we're sending him a demand letter asking him to, informing him that he gets to either waive the arbitration clause, or he's gonna get to explain to a judge with my boss standing at the opposite bench staring at him and breathing heavy and all that other fun stuff. Anyway, let's talk about the temporary restraining order, because I don't think people are really understanding my position on any of this. If you go back and watch my videos on the Leon Valley thing, I am very much in favor of the cops not arresting witnesses. So I don't think the simpletons out there want the good guys in white hats and the bad guys in black hats. And because I'm not just simply shouting along with the prevailing wisdom in this little community, and because I am explaining how the law works, obviously I must be a black hat. I must be against them. But that's what simple minds think. Let's look at that temporary restraining order again. I looked at it last night. Someone had mentioned that it had been granted, and this was at like 8:30-ish last night, somewhere in there, maybe 9. It was late. So I wasn't looking at it with the freshest eyes. But I'm pretty sure my analysis is holding as far as like how strong it is. Like if the temporary restraining order has to be based on the warrant, because that's what is up and available. Now they can add in other things, like they can ask for a temporary restraining order on these cell phones and things like that, but that wasn't pertinent to the Google issue. So, and I have to actually look at Texas criminal procedure to figure out if a temporary restraining order is actually a kind of valid way of stopping. I would assume there'd be some sort of a suppression hearing of some kind. But I guess if you're trying to stop the actual warrant itself, what's going on here? You good? So what is this? Your tail? Is it your foot? Let's see if we can do this. Flashlight. I want. How do I get freaking